Mr. Speaker, from the very onset, from where I sit, from the intention of the drafters of this particular bill, I support the enactment of a law that will help us to grow, develop, manage the governance of our Technopolis. So, Mr. Speaker, I support, but with reservations on a number of provisions in this particular bill, which I will propose that the same be subjected to amendments so that it aligns with the Constitution and ultimately achieves the objectives that the bill seeks to create and advance in terms of technology in our country. Mr. Speaker, part of the larger reason why I support this bill is that the development of ICT hubs across the country, which is one of the projects or programs that the Kenya Kwanza government had in its agenda to the people, is to ensure that we utilize the growth and development of ICT in ensuring that our young generation, Kenyans who are tech savvy, get a benefit of using technology in order to not only create employment, but to earn a living, develop their business ideas, and go beyond the region in ensuring that they get jobs and they utilize their expertise. Mr. Speaker, remember, Kenya is one of the fast growing ICT hubs in the region, and this law, once amended and with various propositions that I believe honorable members will give here, will support that idea to make sure that we position this country beyond the region but globally in matters ICT, in matters technology, and that way we will be expanding the scope of source of employment to the people of Kenya. Mr. Speaker, I come from Bomet County, and there is a region in Bomet called Mulot where we have high-tech boys and girls in ICT. My neighbor, Senator Okongo Mogeni, knows that when you cross over Mulot, you either switch off your phone or you place it on some flight mode because of the technology that is available there. This bill, Mr. Speaker, will ensure that we facilitate and tap to ring-fence such kind of technology to support those young Kenyans, those young Bomet residents, to make sure that we formalize their expertise in ICT and use it appropriately rather than to enhance their utilization of that in what the law is not yet recognizing it as appropriate. And Mr. Speaker, I will comment about the Mulot ICT hub, which once this bill is passed, the direct beneficiary will be myself and thousands of residents and techno-savvy young men and women in Bomet who will be directly benefiting from this particular law. However, Mr. Speaker, when you look at a number of the provisions, I want to go straight to some of them. For example, this is what Senator Muma has commented about, clause 5B, where the proposed law seeks to mandate the authority to allocate land to investors in a Technopolis. Mr. Speaker, Technopolis has been defined in section 2 to mean a zone area which has been ring-fenced for purposes of ensuring that we have got businesses, we have got transactions within the ICT zone, but then the authority has got no role in law, in constitution, to allocate land to investors without, in this particular provision, making reference to the county government, to the National Land Commission, whose mandate in the Constitution is to be involved in such matters, land allocation. It therefore means if this law passes as is, an individual will go to court, challenges the provisions of section 5(1)(b) as unconstitutional, and we will lose the important provisions which are compliant with the Constitution, but for this particular provision. Mr. Speaker, I therefore propose that that particular clause be amended to ensure that it aligns with the Constitution by making appropriate references to other institutions mandated in the Constitution and law for land allocation. Secondly, under the same clause 5F, this is clause 5(1)F, Mr. Speaker, this is what I earlier on said. The role or the mandate that this authority is given is to facilitate realization of Kenya's digital economy by use of emerging technologies to support business within Technopolis. Mr. Speaker, as I said, the Kenya Kwanza Plan had the provision of establishment of over 290 ICT hubs, meaning each constituency, in fact, has been required to provide beyond the constituency to the ward where there should exist a hub, ICT hub in such a place. Mr. Speaker, this in itself will ensure that we cascade the provision of ICT technology, opening up opportunities not only in the 290 constituencies, but in almost each and every ward, thus ensuring that we facilitate the realization of the Kenya's digital economy, which of course, Mr. Speaker, is one of the major source of business opportunities and economy, which economy is built on job creation and marketplace for almost every other aspect of that we do because of the emergence of ICT in the world. This is a very good provision, and I support to the extent that it feeds into what people had been promised whilst this government was seeking to be given an opportunity to serve for this period. Similarly, this will ensure that, of course, whenever we have all these Technopolis, there will be a one-stop shop. When you look at the mandate of this authority, opening up all sorts of business opportunities which are supported by ICT in one area, will ensure that we have got a one-stop shop. By extension, we limit the abuse or rather the misuse of opportunities, because you will be able to do and transact within one area because of all businesses that will be operating within that the Technopolis. Mr. Speaker, the provision of the proposed section, clause 6 on the membership. This is actually clause 6, Mr. Speaker, talks about the authority to have certain powers. Among the powers are what I've said, which are unconstitutional, but specifically under 7, the creation of a board to manage the authority, particularly under clause 7E. Other than, of course, the chairperson to be appointed by the president, there is a requirement, as it has been said by Senator Muma, this is an intergovernmental function. We are creating Technopolis not only at the national level. We are creating Technopolis, and therefore there should be some relationship between the national government and the county government. Among the 9 members of the proposed board or authority, 4 of them represent the national government, and 7E represents 5 persons who the clause seeks to be appointed competitively by the cabinet secretary. Mr. Speaker, unfortunately, there is no reference at all to any representation of either the Council of Governors or the county governments where such Technopolis are to be domiciled from. Mr. Speaker, that is one provision that is very critical. It will not be possible for an authority to be representing certain functions which are devolved in law, and yet there is no representation in the board of the county governments or the Council of Governors. And so, Mr. Speaker, I propose therefore that there should be further amendment to clause 7E, so that among the 5 people who will form members to the board, who are supposed to be competitively recruited, they must be ring-fenced to represent the county governments. If not all of them, at least 3 of the members who will be competitively recruited must be members who will be appointed or nominated by either the Council of Governors or the respective county governments that such a Technopolis will be domiciled from. That way, we will be protecting the interests of the counties, as well as ensuring that certain functions devolved are not only performed exclusive by the national government, but with the involvement of the county governments. The rest of the requirements on the qualifications, experience of these individuals to be nominated is provided for under 3B, which, Mr. Speaker, ensures that there will be a diverse character of personnel that will be represented in the board. That way, we will be having everyone from among engineers, architects, physical planners, ICT experts, law, social sciences, and other relevant fields. This way, we will be able to have diverse representation within the board, and we will tap those experiences to make sure that we maximize the people who will be dealing with the management of the board. And lastly, on this particular one, Mr. Speaker, the appointment at different dates, this is provided for under clause 7.5, is to ensure that not all the 9 members who will be sitting in this board are appointed at the same time. There is a proposal to stagger the appointments, and this, of course, is aimed at ensuring that there will be no time or no period within which all members of the board their term is expiring at the same time. That way, we'll ensure that there is continuity. When one member's term expires, the remaining members in the office can be able to run, and therefore we do not have a lapse in terms of the history, in terms of the perpetuity of the office. The staggering of appointment and nomination of members is welcome, and Mr. Speaker, this will ensure that we achieve what we have across the board made reference to continuity of office. Under clause 18, Mr. Speaker, the clause provides that this authority is expected to collaborate with relevant county government or any other government entity. This is where we are saying it is going to be extremely impossible for the authority to purport to coordinate and liaise with relevant county governments for purposes of collaboration on development of this Technopolis or in any other manner that requires that collaboration when there is no representation in the board of either the Council of Governors and the Council of Governors or any other person representing county governments. This Section 18, Mr. Speaker, will prove to be extremely hard to implement, and therefore it calls upon this particular bill to be amended to ensure that we give them that room to have representation. As I earlier on referred to the ICT hub that is to be developed in the county of Bomet-Mulot, it is the county government of Bomet that is required to provide for the land, and that, Mr. Speaker, has actually been made available. It will not be possible for the national government, whether it's Concert Technopolis or any Technopolis for that matter that will be created if this bill were to be passed, to go down to Bomet, develop infrastructure, get certain approvals, and the county government is not involved. So the provisions of clause 18 all the way to 21 are very critical to make sure that any expected collaboration achieves the objectives of this bill. Without such amendment, it will not be possible because it is not going to be easy for the national government to run without having the support of the county government. Under Part 5 of this particular bill, it's under Technopolis Development Control. This is the same challenge that will come to the development of the control mechanism of the Technopolis in the absence of county governments. There is no clarity under clause 23 on how this control will be achieved, because you cannot expect the authority to regulate zoning, especially where the county government is not involved. There is need to ensure that by the time we are giving the mandate to the Technopolis to control zoning, the county government have a role to play so that whatever zoning that is going to be expected to be done, it is done in full collaboration with the relevant county governments, or representatives of the county government will also, of course, be able to support such particular zoning. The provisions of clause 25 makes specific reference to application and approval of development permits. Under this clause 25, there is no reference at all to any role that any county government were to play. Mr. Speaker, remember, our county governments have got the mandate in law to issue certain permits. It will not then be possible for the Technopolis or the authority to grant licenses where there is no reference to any role to be played by the county governments in licensing, in approvals, or in cancellation of those licenses. Yet, it is one of the major sources of revenue for the county governments to issue licenses to businesses, to issue permits to businesses and related roles. So we will need to still relook at the provisions of that particular clause 23 with regards to licensing. Under Part 5, this is Part 5 on licensing procedure, Mr. Speaker. Clause 29 provides that Clause 29 and Clause 30, they speak not at cross-reference, but contradicts each other. These two clauses needs to be relooked at so that there is compliance in how one is required to apply for license and how that application in terms of whether we are classifying the licenses, where we are giving a certain fee to certain licenses. Clause 29 and 30 should be able to speak to one another so that the law can flow. But specifically under 29C, where it gives a very blanket authority to exempt certain applications from getting licenses before they operate, Mr. Speaker, I propose that the authority should only be allowed to grant exemption on two of the three proposals made. One, if you are a startup business enterprise within the technology and you are on your initial operation stage, you can be exempted if you meet the qualifications as shall be established in the regulations. And secondly, if you are undertaking a collaborative or research partnership with an already licensed and existing entity within the Technopolis. The provision that is proposed to grant another condition of any other person as may be provided for by the authority, by the regulations, is an abuse or a possible abuse of this particular provision in law. We do not need to provide for this in the Act. If necessary, if it must be there, it can only be placed in the regulations which the Cabinet Secretary is mandated to process and prepare for purposes of application. But if we leave this as is, Mr. Speaker, it is prone to a lot of abuse. Lastly, Mr. Speaker, the bill, as I said, is a good bill. It is a bill that its time has come. It will open up the region, the country to the region, and also will facilitate what we are all aware of, because where we are right now, we are in an IT world. Everything else is on the platform of technology, and this bill will ensure that it gives us the support that we require to transition. And as it transitions, if the objective of the provisions of Part 11 on the transition and the saving clauses to maintain and protect the former authority, in this case, Mr. Speaker, this is the Konza Technopolis Development Authority, a number of provisions in the proposed law needs to be relooked at so that we transition appropriately from Konza Technopolis to other Technopolis across the country without necessarily hampering the right of a county to establish its own Technopolis, because as it is, it will mean that a county government can or is actually not in a position to develop its own without referring to the authority, without getting the approval from the authority. And as I've said, there is no representation of county governments through either the Council of Governors or any other representation in the authority. Mr. Speaker, with those many remarks and the proposed amendments, which I hope the committee, unfortunately, Mr. Speaker, I have not seen the chairman of this committee in the House. I hope the members who are members of that committee have followed up the proposals by members on possible necessary amendments to be made on this bill so that it be passed and it serves the purpose that was aimed at. Otherwise, as is, Mr. Speaker, there is still a lot to be done to make sure that this bill is a representation of the desires of the Technopolis and those who have come up with this particular bill. Mr. Speaker, I thank you and I support.
Very well. Senator Veronica Duarte.
Thank you. Thank you, Honorable Speaker, for the opportunity to contribute to this very important bill. From the very onset, I think the intention of the proposal of this bill coming from the National Assembly was intended to regulate a field, the field of technology, which is emerging and which is developing at a very fast pace.